Hi, in today's video, we're going to talk about how to get a divorce in Nigeria. In my first video, I talked about what you should do first before you make that big decision to get a divorce. So this is the second part of my 10-part series on divorce. So if you haven't watched that video, you need to go and watch that video. I'm going to put the link in the description so that you can go and watch it. In today's video, I'm going to be talking about types of marriages. If you did only traditional marriage, or you did only church marriage, or if you are married but you live abroad and you want to get a divorce, or you are in a polygamous marriage. I'm going to be talking about custody of children. I'll be talking about marital properties and a whole lot of other things. So you want to watch this video to the end. So let's just get right to it. So hi everyone, welcome to the channel. My name is Joy. I'm a legal practitioner in Abuja, and I specifically specialize in corporate law and family law. I'm doing a 10-part series on divorce. So you want to watch all the videos in this series to the end. If you haven't already subscribed, make sure you subscribe and put on your notification bell so each time I post a video, you get notified. So the first thing we're going to be talking about before we get to the point of how you can get a divorce in Nigeria is the types of marriages. So under the law, there are two types of marriages that are recognized under the law, or three rather, but we're just going to be talking about two. The third one is Islamic marriage. That one is already governed by Islamic law. So we're just going to be talking about the two that are recognized under the law. The first one is marriage under the Act, which you also call church marriage, and which is also called marriage in the registry, what people popularly call court marriage. So if you went to marry in church, usually they will give you a marriage certificate that looks like this. Even if you did a marriage in the registry, usually when you go to church, they'll tell you, have you done the one in the registry, or have you done court marriage? You need to go and do court marriage. Some churches that are licensed will just go ahead and give you this certificate after your church wedding. But those people that didn't do church wedding, you just went to AMAC, the marriage registry, and you got a marriage certificate. You did all the ceremony and everything, and you got that marriage certificate. You are married under the Act. Now, the second one is traditional marriage, which we call customary marriage. That one is where they go and pay your bride price. If you are the woman, they pay your bride price. The man goes to your village and pays your bride price. Even if you don't do a marriage under the Act, even if you don't do white wedding or anything, that marriage is recognized by law. The law actually says that you should go and register that marriage in the AMAC, but a lot of people don't do it. It doesn't mean that the marriage is not recognized. So now that we've understood that, you will now know which one you fall under. So the next question will be, which court are you to go to get the divorce? If you did marriage under the Act and you have this certificate that I've been talking about, it will be high courts of any state. The law is that, okay, let's say for instance, right, you were married and then you had issues and you moved out of that state. Let's say you married in Yobe State, or you married in River State or Port Harcourt, and then you had issues, or your partner left or you left, and you now live in Abuja. It is where you lives. That is where you are. That's the court or the high court that you are going to go to. The law is that any court in the state, that's the simplest way to just explain it. Any court that the petitioner is domiciled, that's the person who wants to divorce, lives. That is where the person is going to file. And it can be in any state. So any state of the federation at all. It doesn't matter if you did not get married in that state. It doesn't matter even if your other partner is not living in that state, as long as you have an address in that place where you want to file for divorce, and that is where you live, that is where you can file for the divorce. So if you did a statutory marriage, marriage under the Act, church marriage, and you have that certificate that looks like this, then you will go to the high court of any state in Nigeria, usually where you live and where you have your address. So if you did traditional marriage or you did customary marriage, which is the same thing, then you would go to a customary court, because that is the court that is responsible for handling cases like this. So you go to a customary court where you live as well. And the first thing you need to do before you do that is probably you need to go and do what is called returning of the bride price. Okay, so your people or your family will have to go and return the bride price before you now come to the customary court, to get a declaration of divorce. So, what are the grounds for a divorce? What is the reason that you need to tell the court that you want the court to end this your marriage? It can stem from a lot of things, from infidelity to drunkenness to the fact that your partner is not performing their conjugal rights, meaning that your partner has refused to have sex with you or has refused to sleep with you, and a whole lot of other things. Another reason could be that there's physical abuse, there's verbal abuse, and or your partner has abandoned you for a period of time. Now, this topic for grounds for divorce is a very broad topic. So in my next video, I'm going to be explaining it properly. So this is just me just listing it. What are the other alternatives that are open to you apart from divorce? Now, if you don't want to have a divorce or you feel like you still want to save your marriage, fine, there are other reliefs. There's what we call judicial separation. So instead of getting a divorce, you can ask the court that you want to be judicially separated for a period of time to see if you can resolve your conflict, and then you can come back together again. Another option would be restitution of conjugal rights. That is, if your partner has refused to consummate the marriage, since you got married, you've been trying to sleep with your partner and they don't want, or they are giving you excuses, or they don't want, or some things, or maybe because for some reason you really can't explain and you've tried everything, you can come to the court and say you don't want a divorce, you just want the court to restore your conjugal right, to make your partner, or to, how do I say this? To, I don't want to use the word first, right? To make your partner uh, perform their rights or perform their duties to you. So you can go through that route if you don't want a divorce. So, like, how much does it cost to get a divorce? Now, for you to know that it varies. No lawyer charges the same, but we have what we call like a scale of charges for legal practitioner, and that scale of charges kind of sets out how much, or the minimum charge lawyers are meant to charge clients. So the difference mostly is in the experience of the lawyer. Like for me, now that I'm over 10 years, they have, where there's a grading system, right? So for people that are less, the charge is different. And it will also depend on the states. If you are in a state like Lagos or Abuja, where cost of living is a bit higher, or yeah, maybe in Ondo State, the cost of living is less, or Abeokuta, of course it will be less. But if you are living in somewhere like Port Harcourt, it is higher. So lawyers will definitely charge you more. So they can charge you from like 800,000 and above. It all depends, except if you can get an NGO. I know there are NGOs. In this series, I'm going to do like NGOs that you can get free legal services, or NGOs that can charge you just a token. They won't charge you much because they augment for you or add money or help you through that process. Okay, so except that, it can range from about that to, or even less. Like if it's a younger lawyer, if it's a lawyer that is like 5 years and below or something, they will charge you less. Now, for people that did only traditional marriage, of course the fee is going to be lesser than people who did court marriage or marriage under the act, because of the process or the procedure. The lower courts are what we call court of summary jurisdiction. So everything there is fast, 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 and it is easier, But in the high court, everything is procedural. Everything has to be properly done, and it has to be done well. So of course they are not going to charge you the same way they will charge you. So it varies, or it depends. I can't really give like a specific figure at this point, but I know that it varies, depends on the lawyer, depends on the state, depends on if the case is contentious, if it's going to be something that is going to be problematic, both for you and your lawyer. Of course they are going to charge you more. So it all depends. So if you did like only traditional marriage, right, or if you are in a polygamous marriage where you are not the only wife, you can go to the customary court. After they have returned the bride price, you can go to the customary court, and then they will also give you like a declaration. But the issue with customary court is they don't have the power to make declarations as to issues of maintenance for children, and issues as to division of property, marital property, and the likes like that. So if you did, that's why we keep advising people, like, don't just do traditional marriage. Make sure you do marriage under the act. It protects both the man, it protects both the woman. So it protects both of you in issues like this. So I get asked a lot this question, like, what happens to the children? Who gets custody of the children? Let's say there are children in the marriage. It's easier to get a divorce if there are no children. But if there are children, you already know that there are going to be issues um, as to custody and issues as to maintenance of the children. Now, in the issue of custody, what the court looks at is not the man or the woman. What the court really looks at is the interest of the child. Will it be beneficial for the child to be with the mother or with the father? In most cases, it is usually the mother, right? Because the mother is the one that gave birth to them, and then mothers are nurturers. So usually it will be in the interest of the child. But it's not in all cases that it leans towards the woman. In some cases, it will be the man. Maybe the woman will be busy, or usually the man has been the one taking care of the children. Maybe the mother was not there for a while, or the mother is a busy person, is a work person. The court can say, okay, the children should go to the man. But it is not in all cases. So it varies, but usually it is in the interest of the children that the court will look at, to the emotional interest, their psychological interest, their physical interest, if they are minor children. Now, the law is that when the child is above 21, right, they are no longer minor children, or 18, they are no longer minor, they are now adults. So they get to choose. Nobody gets to choose if there's custody or anything. They are just children of the marriage. So the court will not decide. But when they are minors, when they are below 18, of course, the court will be left to decide who gets the children, except if you can come to an agreement where the man will say, okay, you as a woman, you're their mother, keep the children, or the woman will say, you as a man, you can keep the children. And then there's going to be an issue as to visitation rights. Okay, whoever is having custody of the children will have to give the other partner visitation rights. That means that other partner is allowed to come and. Now, in the issue of maintenance, the law is that where the child is 21 years of age, the issues of maintenance will no longer arise. So that means that, if they are adults, like I said, in the issue of custody, it will not arise. But if they are adults, or maintenance will not arise. Now, where they are minor children, of course, now the law is stating that, it is not contractual. It is not based on whether you like it or not. It is saying that a man must care for his children. So where there are minor children, the man will have to, be paying a stipend. If the woman is supposed to be in custody, of the children, or if the man is in custody and the woman, is working, or the man can decide, okay, no, I'm the one in custody, I'll just take care of the children. But where the children are with the woman is supposed, or the man is supposed to be paying a monthly stipend for the children's feeding, their health, or any other thing. Now, the issue of school fees, that will also be decided by the court. If the man is more well to do, of course, he would have to be paying the children's school fees and other bills, right? And then in the issue of, sometimes the court will say, okay, he'll pay some part of the rent until the woman gets married. If she's not married and the children lives with her, he can decide that he wants to pay a part of the rent, or he wants to pay all of the rent. It's not in all cases. In most cases, there's usually always issues as to house rent and all of that, because usually the man doesn't even want to be involved in all of that. But he is required by law, even at that, to pay a monthly stipend to take care of the children. Even if the children are with the woman, he's meant to pay a monthly stipend for the children, and also to take care of their school fee. Issue of family property, where there is family property. Now, during the course of marriage, you probably, both of you, bought a property together, and your name is listed, or your name is indicated in the property as co-owners of the property. Or in some cases, some people will ask that, what if I was married to the man, and he bought the property while we were married together, and I supported him, in our own law is different. It's not like what you watch in movies, right? So the issue, or that is usually always very contentious. I'm not going to go very deep into it, but all I can say is, if there was property during the marriage, and it shows that both of you supported, as in your money was there, or you can prove to the court that you were available emotionally and you supported your spouse in buying those properties and you want to share it together. What the courts will usually do is they can say, okay, they want to sell it, and then both of you can share it, or you can decide that, okay, you take this, you take that. But it's usually always very contentious. Okay, so if you can prove or you have evidence, like I said in my first video, that before you go about all these things, you need to have evidence, you need to prepare, you need to plan. Okay, like I said in the lower court, if you did only traditional marriage, it's easier. You can go ahead, do that by yourself, go to the court, they can explain. But it is better you get the services of a legal practitioner. It is neater and it is safer for you, for somebody who has a better experience, so that the other person who has a lawyer, a better understanding, will not come and then turn things against you. Now, if you did marriage under the act, you need to get a lawyer. You need to contact a lawyer to get a divorce done for you. Okay, I hope this video was helpful to you. If it was, please make sure you subscribe and put on your notification bell, so each time I post a video you get notified. In my next video